My name is Gemma Yates. I'm the Investor Engagement Lead here at ACCR, and I'll be hosting the webinar today. I would like to start by acknowledging the First Nations people of the land that I'm on, the Gadigal people of the Eora Nation, who are the traditional custodians of this land. I would like to pay my respect to elders, both past and present. So thank you very much for everyone dialing into the Santos AGM webinar today. I know it was short notice. This will be an express 30-minute format, but we should still have time for Q&A at the end of the presentation. So if there are questions that do arise while either Alex or James is speaking, then please just pop the questions into the Q&A chat at the bottom of the screen. Just also be aware that we are recording this webinar today. So joining me is James Fitzgerald. For those that don't know, James is ACCR's in-house General Counsel. James has worked as a lawyer, negotiator and strategist for more than 28 years. He has been closely involved in the development of native title law and land use policy during his career, and has worked with Indigenous communities, governments and industry to help form land use policy and to advise on legislation development. So James brings a lot of authority when talking on the Tiwi Island case today. I'm sure many of you know Alex Hillman already. He is ACCR's lead analyst for Santos, and he will discuss our analysis of the Santos REM report and also our thoughts on director elections as well. If anyone does have any follow-up questions after today's call, then please do just reach out. Alex, if we want to pop up the presentation quickly, you can see my email address is there. Please, if you have any follow-up questions, for either James or Alex, just reach out. We'll be very happy to get back to you and answer them as soon as possible. With that, I will hand over to James.
Thank you, Gemma. Welcome, everybody. Thanks for joining us today. Just noticed there, I'm such a veteran of ACCR that my email address is actually james@accr.org.au. I think we've got a standard format now that I haven't caught up with. So there you go. I've been asked to speak to you today about, just to give you a brief indication of what's going on in proceedings that ACCR has going against Santos Limited, and also to talk about the Tipa case, the so-called Tiwi Islands case involving Santos Barossa. So I'll just start off with a brief update on the legal proceedings that we have going. Many of you will already know that in about August 2021, ACCR commenced proceedings against Santos in the federal court with a claim that in its 2020 annual report and in subsequent documents and communications, Santos engaged in misleading and deceptive conduct in its representations about gas as, quote, clean energy, and in relation to its claims to have a, quote, clear and credible, end quote, plan to reduce its scope 1 and 2 greenhouse gas emissions 26 to 30% by 2030, and also to achieve net zero emissions by 2040. The proceedings have subsequently been amended to include an additional claim in relation to the characterisation by Santos of its blue hydrogen proposals. Where are we at now? Amended pleadings have been exchanged in the last year. The discovery process has largely been completed, and some expert reports have been filed. Towards the end of 2022, we were sorry to lose the judge managing the matter. That was Justice Jago, who was elevated to the High Court. And it was some time before another judge was appointed. In mid-December, we heard that Justice Lee, an existing judge of the federal court, would take the matter up. And in the last month or so, we've had our first directions hearing in that matter convened by Justice Lee. As a consequence of that directions hearing, the parties are now engaged in a court-supervised exercise to reduce as far as possible the relevant facts in dispute. The way that works is that the barristers for the parties primarily are meeting in the company of a judicial registrar and working through a proposed statement of agreed facts and facts in contention so as to reduce to the bare minimum necessary the issues that will need to be determined by Justice Lee in due course. It's expected that that process of conferral will be finished during April. It's then anticipated that we'll have a further directions hearing towards the end of May 2023. And we are expecting at that time that a hearing date will be set for the final determination at first instance of any issues that aren't resolved through the current conferral process. Now, the second thing I've been asked to comment on, or at least give you an update on, is a proceeding involving Santos NA Barossa Limited that's attracted quite a bit of interest and attention. And that is the matter of Santos NA Barossa Proprietary Limited versus Tiwi Islands. Last December, the full federal court upheld the prior decision of a single judge to set aside a decision of the National Offshore Petroleum Safety and Environmental Management Authority, otherwise known as NOPSEMA, to accept a drilling environmental plan lodged by Santos in relation to the sinking of 8 gas wells for the Barossa project in the Timor Sea, directly north of the Tiwi Islands. Tiwi Islands are, of course, off the coast of Northern Territory. The applicant for the original judicial review of NOPSEMA's decision approving Barossa's environmental plan is a fellow by the name of Mr. Dennis Tiwi Islands. Mr. Tiwi Islands is a Tiwi Islanders traditional owner and elder with unregistered traditional interests in the seas surrounding the Tiwi Islands. Mr. Tiwi Islands claimed that Santos failed in its duty to consult him and other Tiwi Islander traditional owners under the Offshore Petroleum and Greenhouse Gas Storage Environment Regulations of 2009. Mr. Tiwi Islands contended that Santos should have consulted with him and with others under the regulations because of his and others, quote, interests or activities that may be affected by the activities to be carried out under the environmental plan. In other words, Mr. Tiwi Islands contended that he was a, quote, relevant person, i.e. a person that needed to be consulted with for the purposes of those regulations. Now, the Tiwi Islands are held as Aboriginal land under the Aboriginal Land Rights 1976, but there is neither a native title claim nor a native title determination over the sea countries surrounding the islands. Even so, there was plenty of evidence, including led by the Northern Territory Environment Centre, given to NOPSEMA about Tiwi Islanders' traditional and cultural use of the waters surrounding the islands before NOPSEMA made its decision. The court also noted that Santos did not dispute the evidence that was provided to NOPSEMA about the existence and the validity of those traditional interests in the sea country. As a matter of fact, Santos did consult with the Tiwi Islands Land Council, but it did not consult with Mr. Tiwi Islands and other Tiwi Islanders at all, i.e. those with interests, traditional and customary interests in the sea country around the islands. The full federal court concluded that Mr. Tiwi Islands and other Tiwi Islanders did indeed, or do indeed, have interests within the meanings of the regulations, and particularly Regulation 11A, that is, interests that could be affected by the activities Santos is proposing, and held further that, and I'm going to quote this, Santos did not address these matters in the drilling EP as we consider they should have been because of the mistaken approach adopted by Santos and NOPSEMA to the concept of interests in Regulation 11A. The nature of the misunderstanding or the misinterpretation of interests there appears to revolve around whether there was a registered interest or not. As I mentioned earlier, while the Tiwi Islands themselves are registered as Aboriginal land under the Aboriginal Land Rights Act, First Nations people with traditional and customary interests in the sea country have not yet had their interests registered in the, by way of the Native Title Act. But for anyone who has studied Native Title 101 or has worked in this area will tell you The concept of native title as recognised as Australian law doesn't involve the Crown or the government granting interests to Aboriginal people. The underlying philosophy of native title law in Australia is that Aboriginal traditional connection to country through observance of laws and customs has subsisted since time immemorial. The process of registration of those interests is merely giving formal recognition to them rather than granting them from the beginning. What we can see here is that both NOPSEMA and Santos appear to have assumed that the only people they need to consult with were people with a interest sitting on a register somewhere in a government office. The court was essentially saying, no, you knew about the existence of people who have interests in that country, traditional and customary interests, use that country, and you should have identified them and followed the procedures for consultation with them. One of the responses of Santos and NOPSEMA's submission in the full federal court appeal was to the effect that the court's interpretation of interests, i.e. including unregistered interests, renders the relevant legislation, quote, unworkable. Now, the full court responded to that directly and said, quote, we see no particular difficulty with the proposition that the First Nations people who have a traditional connection to the sea and to the maritime resources it holds, which may be affected by Santos's activities under the drilling EP, are reasonably ascertainable. You can find them. You know, in fact, there was evidence before NOPSEMA that they existed. The full court, and on that basis, the court found that NOPSEMA erred under its duty under the regulations to receive and accept Santos's drilling plan in circumstances where people with relevant interests were not consulted. Now, the full federal court emphasised that the problem in this case, such as it was, lay with Santos's and NOPSEMA's misunderstanding of the regulations and Santos's failure to satisfy those regulations, rather than with any unworkability in the court's interpretation of those regulations. That's the summary of my understanding of the case. Alex, you may be able to tell me if I'm right or wrong here, but we were a little disappointed in the days immediately after that decision to hear reports that Santos had commenced plans to lobby the government to change the regulations on the basis of unworkability. To my knowledge, there have been no changes since, but it really is worth stressing that last paragraph. The court's making clear the problem here isn't the law, it's the way people are operating under the law. That's all I have, Gemma.
Thanks, James. Excellent. Alex, we'll get stuck into the next part.
Yeah, just speaking of James's point around potential changes to the regulations. So my understanding is industry broadly is quite unsettled by this. So, Santos's actions is having broader industry ramifications. Although ACCR has a set of political analysts, there's obviously a lot of focus on the voice of Parliament at the moment. And so it's an awkward time, let's say, for industry to be asking the rights of interested traditional owners to get less priority. So we wouldn't expect, I wouldn't expect to see any changes that soften and weaken the regulations anytime soon. The substantive bit that I'm going to talk to is the remuneration report that Santos has put out. So as people are probably aware, there was a first strike. There was 25.3% of votes cast at last year's AGM were against the remuneration report. So that means Santos is on a first strike. And the consequence of that is if there's another 25% vote against this year's remuneration report, there's a contingent resolution to spill the board. So it's an explicit element of the Corporations Act and it has significant meaning, which I think is relevant when you consider how Santos has responded to that first strike. So a lot of the challenge against last year's remuneration report was this CEO, it was called the CEO Growth Projects Incentive. It's had a slight name change. It's now the CEO Growth Incentive. So it's an Australian $6 million ad hoc bonus. It doesn't actually sit within Santos's executive remuneration framework. So when they articulate how they structure executive bonuses, this isn't part of their framework. And it's based on both ongoing tenure of the CEO to the end of 2025, as well as, and I quote, strict performance conditions for a range of projects.
So when we look at the projects that are listed in this and some of the challenges that Santos has had, we see a lot of overlap. And I think that raises queries about whether or not this ad hoc bonus is encouraging behaviour which isn't in shareholders' interests and may even be putting legal compliance at risk. So there's two categories for these projects. One of them is major growth projects, effectively fossil fuels, and the other is low carbon issues. So as James mentioned, we're currently in litigation around Santos's low carbon claims. So I won't talk to those anymore, but in terms of the fossil fuel elements, the Barossa project is the first one of these. As James provided in an update to the Tiwi Island case, it was found by the full fed report that Barossa drilling campaign never actually had environmental approval to commence. And a consequence of that was, despite the drilling having commenced, a rig was mobilised. That drill rig was then demobilised, so it stopped drilling, it was demobilised and moved out of the location or the vicinity of the drilling campaign. My understanding is it's still there. And these rigs are expensive vessels to be hiring. Santos's original response to the market was that there was going to be no cost or schedule impact. At the last investor briefing day, they completely changed how they were communicating that and saying that there was no update on cost or schedule impact. So they've gone from being, one could argue being a little bit dismissive of the consequence of this, to understanding, to now communicating that it's an unknown risk over this project. And it wasn't just the drilling campaign that got impacted by this. As we've seen with other more dramatic examples where industry hasn't met community expectations, Santos's pipeline environmental approval was also, NOPSEMA also requested that they can conduct additional consultation before commencing the pipeline activity. So a pipeline vessel has hundreds of people on it. The pipeline activity, as we understand it, was a few weeks away from starting. So presumably that had been mobilised or nearly mobilised. Everything would have been lined up, and then that pipeline vessel is not currently executing the pipeline activity. So again, we've got a massive, expensive mobilisation of vast resources, which has been, delayed and deferred, presumably at Santos's cost, because of this failure to adequately consult with traditional owners. When we have a look at the second item that is in this growth project, it was the Dorado project. So this is an oil development off the coast of Western Australia. Last year in August, its FID was delayed. We would raise questions. So obviously, if you're going to delay FID on a multi-billion-dollar project, you're going to do that because it's not a compelling argument to make FID. So we see some conflicts between shareholder interests who are looking for financial returns with heavily incentivizing a CEO to deliver a project which is demonstrably marginal. We think that's a questionable way to set up a remuneration structure. This year, there's been a little change, and PICA has added. So as a consequence of the oil search merger, PICA has been provided not in addition to what was on this list of projects to be delivered, but as an alternative. So it's not Dorado and PICA, it's Dorado or PICA. So you can see that, I think that raises questions about the independence of the board when they're setting this remuneration structure. It seems to be softening and increasing flexibility over time, which for a long-term incentive scheme seems a bit counterintuitive. The third major growth project, i.e. fossil fuel project, is around backfill resources. The definition of what that isn't terribly clear. The remuneration report talks about how if there's additional backfill to the midstream assets, then it increases utilisation and profitability. But that's kind of like a reason to do backfill as opposed to a specific objective or an activity or an outcome that they're chasing. So across the suite of these growth projects, we don't see a compelling argument for why these are the growth projects that are being incentivised, and where we see there's been incentives in place, we're not seeing compelling outcomes. When we look briefly at the rest of the remuneration report, in the corporate scorecards, there's an element there for landholder, community and traditional owner relationships. The board used some discretion, said that the stretch target was met for this, but because of the issues with the Tiwi traditional owner consultation, that was moderated down to threshold. So Santos has taken steps to reduce the bonus paid for community consultation. But we think it's inappropriate that there's any bonus paid for that measure, considering the severity of the court ruling, the full federal court ruling against them. From a climate perspective, the International Investor Group on Climate Change has recommendations on oil and gas company remuneration. And some of those that are more relevant is that it should include clear scope 3 targets and it should not incentivize production. Santos's incentive scheme does include a hefty bonus allocation to production, so both fossil fuel expansion as well as actual production in terms of buoys. And the scope 3 target, we would argue, is not substantive. So the closest they have to a scope 3 target is to sell enough LNG to displace emissions. But we think the premise that additional LNG sales actually reduces emissions is fundamentally flawed. And so we don't consider that to be a valid scope 3 target. In the long-term incentive space, there's 4 measures. 3 of these are sound, but one of them is indexing total shareholder return against effectively an oil and gas industry. So the Standard & Poor's Global 1200 Energy Index, where the oil and gas sector underperforms the broader market, that performance against that index is not necessarily going to align with shareholder returns. And I think, as we can see from the World Energy Outlook from the IEA last year, oil and gas are both forecast to be declining markets in every climate scenario that the IEA is projecting. So tying incentives to success relative to a declining industry doesn't seem like an optimum outcome for investors. For those investors who do prioritise or see value in oil and gas benchmarking, Santos has fairly dramatically underperformed. So we had a look at a selection of local and global peers. Santos's total shareholder return of 17% dramatically underperforms those other 5 that are listed there: Woodside, Beach, Shell, Chevron, and Exxon, who all delivered between 29 and 100%. So on the basis of the growth incentive being perverse and a range of other issues, ACCR intends to vote against the 2023 remuneration report. In addition to that, we think that the way that the Santos board has responded to the first strike is disappointing. So as I mentioned at the start, a first strike is a serious consequence under a deliberate clause of the Corporations Act. It's not just of passing interest. It has a specific legal meaning, and it's designed to focus attention on remuneration structures. Rather than make changes to address these concerns, there's a page or 2 in the remuneration report justifying the structure and why no changes have been made. So, we're currently, actually I won't compare to Woodside, but just focusing on Santos. The most notable change that we've seen is that the growth project incentive actually became more flexible. So instead of reacting to criticism about, an overly generous bonus scheme, they've actually made it easier to receive that, in our view, overly generous scheme. Yasmin Allen is the director who is the chair of the People, Remuneration and Culture Committee. She is up for re-election this year. So as the chair of that committee, we feel that she holds particular responsibility for this remuneration report and the response or inadequate response to the first strike. So as well as voting against as well as ACCR are going to vote against the remuneration report, we will also be voting against the re-election of Yasmin Allen. So that's the slides done. Should we quickly throw to questions, Gemma?
Thanks, Alex. Well, we've got 2 minutes. So if anyone has a question, one for you, James. Thanks, John. James, my understanding is that the court in the Barossa case set some instructions for NOPSEMA to better consult with interested individuals. Does ACCR have any views on whether those instructions are adequate?
Yes. To the extent that I understand the court's recommendations there, they're essentially what they're inviting industry to do is look beyond title registers, registers of claims, registers of native title, registers of Aboriginal land rights. They're saying, look, do the work, make an effort to find out who's got an interest in these places, because as we mentioned in the course of the presentation, native title doesn't owe its existence to any sort of recognition by the government. It exists anyway. That's the core proposition of the Mabo No. 2 case of the High Court. So they're saying, look, you need to make an effort to ascertain whether there are interests there. And if there are, then to consult them in accordance with the prescription in those regulations. And the means to address any concerns expressed in the consultation should then fall out into the environmental plan that's then produced. So Santos didn't get to square one because even though they knew of the existence of people with relevant interests, they didn't consult them. Now, the industry will argue, I've been through numerous, public policy debates with the industry over native title in the past. They will argue that, anything that isn't very simple is unworkable. And the court has come back and said, no, look, this is actually an Australian cultural issue. This is about, perhaps we were a resource colony at some time in the past, but it's time that we start to show, having recognised the existence of prior interest in this country by First Nations people, we really need to up our game on respecting those interests.
Thanks for that, James. And one last one for you, Alex. Following the disastrous Say on Climate vote, has Santos improved the credibility of its approach and disclosures in any meaningful way?
Might just check with my lawyer before answering that question. It's going to encourage on anything that we shouldn't relative to the market.
Well, can I, may I jump in there?
Yes, of course you can.
We are constrained in what we can say in this regard because we've commenced the proceedings that I've referred to and that Alex has referred to. But let me say this, we wouldn't have gone to the time, trouble and effort to commence the proceedings if we didn't have concerns.
I hope that answers the question. So thank you everyone for giving us half an hour of your precious day. We do appreciate it. And as I said, if you do have any follow-up questions, don't hesitate to get in touch with any of us, and have a wonderful day.